Antonyuk versus Hochul. Let's go ahead and talk about it. Sup, Wolverines, and welcome back to the channel. Today's story takes place in New York, which is the home of Wall Street, and right now we are in a bear market. Our 401ks and IRAs are suffering. I'm diversifying mine a little bit by adding physical gold and silver, and you can too by going to Lear Capital and finding out about their Advantage IRA, where you can transfer your money over tax-free and penalty-free. It is a great opportunity, and you can get your free precious metals investors guide by calling Lear Capital at 1-800-741-0551. That's 1-800-741-0551. Call them today. They are a great company. They have a near perfect rating on Trustpilot. They have over 3 billion in transactions, been in business for 25 years. They are a conservative company, and they are an American company, and they support the Second Amendment and gun rights. So give them a call at 1-800-741-0551. Support the companies that support us. So give them a call at 1-800-741-0551. If you don't want to give them a call, you can always check out their website, which is listed down below in the description. All right, with that over, let's talk about Antonyuk versus Hochul. Antonyuk versus Hochul is a case challenging New York's CCIA, which is a Concealed Carry Improvement Act. It is the predecessor of Antonyuk versus Bruin. In that case, the judge found the laws all to be unconstitutional, but ruled Antonyuk did not have standing because he was too law-abiding, and he was not planning on breaking the law if the CCIA went into effect, which it did. So GOA is coming back now and suing everyone in the state, basically, and they added plaintiffs to the case too that do plan on violating the CCIA, which should give the plaintiff standing. Last week, GOA asked the judge for a temporary restraining order against the CCIA. Now the judge has heard both sides of the argument from the state and from GOA. I have a feeling that this is going to be a tough decision for him because he doesn't want to strike down the law, but he does know it's unconstitutional. He kind of painted himself into a corner when he dismissed the last case, which, for one, I've never seen done before. I've never seen any plaintiff have their case dismissed because they were too law-abiding, but I guess there's a first time for everything. Now, with these new plaintiffs that say they are going to violate the law, that should give plenty of standing. You have no duty to obey an unconstitutional law, and the judge made it very, very clear during Antonyuk versus Bruin that this law is unconstitutional. So we'll just have to see how he rules. He did not give a timeline as to when his decision will come out. It's a TRO, which is temporary restraining order, so I have a feeling that it's going to come out sooner than later. Usually with TROs, they don't make you wait weeks and weeks. It's usually issued a lot faster than a preliminary injunction or permanent injunction. If GOA does get the TRO, that will be in effect until they get a hearing for the preliminary injunction. Then if they get the preliminary injunction, then they go for a permanent injunction. If they get the permanent injunction, the state will probably appeal to the circuit court. And if GOA loses here, I'm pretty sure they will appeal to the circuit court. And then whoever gets to the circuit court will probably get a 3-judge panel, and whatever that 3-judge panel decides, it is almost a guarantee that the other side is going to ask for an en banc, which means the full bench will hear the case. then if they do get an en banc, because the circuit court doesn't have to grant an en banc, but they can, the full bench will rule on the decision. Then from there, the next stop is to file a writ of cert or certiorari with the Supreme Court, which is a petition to the Supreme Court asking them to hear the case, which the Supreme Court might or might not. I have a feeling that the Supreme Court will hear this case if it does get up there, because Thomas said that you cannot make sensitive areas everywhere, and it has to be used sparingly, and you cannot make an area a sensitive area just because people gather there. New York did that with Times Square. And there's also some property rights stuff in there, and I think New York has just overstepped its boundaries, especially with stuff like good moral character, because the Supreme Court specifically said you cannot use proper calls. So New York just basically changed the name of proper calls to good moral character, and they're playing games, and the Supreme Court usually doesn't like that. But we will have to see. That's years down the road before it gets there. Right now, we just need to concentrate on the district level, and we will see how this judge rules. All right, guys, I got to go catch a plane. I'm flying out to Dallas. I was supposed to go to Georgia, but yeah, that didn't happen. So I'm flying to Dallas now, going out for the gun rights policy conference with a very special guest that you will see later. It's going to blow your mind. All right, guys, I love you. Stay ever vigilant. Stay ever free. Keep in the fight. I'm out of here. Wolverine's motherfucker.